Hello. Good evening, Singh sir. Hello.
हाँ कल्पेश जी,
हाँ
गुड
सर.
इवनिंग।
गुड इवनिंग. गुड नमस्ते सर.
नमस्कार नमस्कार, हाउ आर
नमस्ते.
यू?
हाँ सर. बस यार सर बढ़िया सर. Thank you very much sir.
सो वी आर स्टार्टिंग एट 7.
Yeah sir. We will be starting at 7. So people are joining. Okay sir.
थिंग्स आर फाइन, यस।
Okay sir. No, Puja Lakshmi, can you check your mic?
Hello, sir. Am I audible?
Yes, yes, you're audible. Yeah. We'll be starting sharp 7 o'clock. Sir has joined. सर इंट्रो पीपीटी के बाद आई विल आस्क यू टू अपलोड योर पीपीटी.
Yes, yes.
A very good evening, one and all. I hope I'm audible.
Yes, yes, Pooja. Yeah.
I invite each and every one of you to embark on this transformative journey of professional growth, collaboration, and innovation. Let us embrace the challenge of we can shape the future of legal education. Welcome to the first ever 1 month national level online faculty development program on teaching law in the 21st century, a collaborative effort between Law Teachers India and Gujarat Maritime University, Gandhinagar. This program is a testament to our shared commitment to advancing legal education and preparing educators for the challenges and opportunities of the 21st century. Today with us, we have our faculty coordinator, Professor Gaurav, who is a PhD scholar in the Faculty of Law, University of Delhi. His research area is cyber crimes and child protection. He is also taught as visiting faculty in Campus Law Center, Faculty of Law, University, Delhi. Sir was a senior researcher in Central Ministry Project and various other collaboration with Campus Law Center, Faculty of Law, and including Ministry of Housing and Urban Affairs. So has taught different subjects like contract law, property law, cyber law to BA and LLB students, BLLB students and LLB students. Over to you, sir.
Thank you, Pooja. Am I audible? Am I
Yes,
audible?
sir. Yes, 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 Gaurav. Yeah.
Good evening, everyone. Today's session, we are having the subject of contract law. So, introducing the session, the contract law in India is governed by the Indian Contract Act 1872. The first part contains section 1 to 75, which deals with general principles of contract law, which are applicable to all types of contracts, irrespective of their nature, while the remaining sections deals with the particular or specific type of contracts like indemnity, bailment, agency, etc. Two more legislation, the Sale of Goods Act 1930 and the Indian Partnership Act 1932, were also formed from the parent Indian Contract Act to deal with these provisions in more detail. Now, the contract law has a special value in legal education and in the life of a law student, because in most of the university syllabus for 3 years LLB course, it is usually taught in first semester, and for BLLB 5 years course, it is usually the first law subject taught to the law student. In other words, we can say contract law serves as an initial bridge in interaction with law in the life of law student in his journey from a layman to a legal professional. So it is very important and becomes the responsibility of law teachers to use suitable teaching methods and tools to make contract law subject more interesting for the students with the help of practical examples and illustrations. Further, students can easily relate to principles of contract law in their daily life transactions also. So, to throw more light on the subject and guide us with their practical expertise, I would like to invite our today's resource person, Professor Dr. R.K. Singh, Professor of Law, Gujarat National Law University, Gandhinagar. We welcome you, sir. And I would like to give a brief introduction of our guest. Professor Dr. R.K. Singh is a professor of law at Gujarat National Law University and has over 17 years of teaching experience, including around 14 years at the PG LLM level. He did his BLLB and LLM from the University of Allahabad and PhD in law from Gujarat University. Currently, he is pursuing postdoctoral in law program LLD from Chanakya National Law University, Patna. He was formerly the Dean Academic Affairs of GNLU. In the year 2016, he was selected for deputation as ICCR, Indian Council for Cultural Relation, rotating chair, visiting professor of Indian Studies at Leibniz University of Hanover, Germany for a period of 1 semester. He was awarded the Education Leadership Award at the 26th Business School Affair and Devang Mehta National Education Awards regional round for the year 2018. Furthermore, he was also the recipient of the Excellent Faculty Award by Gujarat National Law University, Gandhinagar for the year 2009 to 2010. Professor Singh is the author of a book titled Law Relating to Electronic Contracts, published by LexisNexis. Besides, he has published research papers and articles on a range of subjects, particularly legal education, constitutional law, and contract law. He has coordinated or offered certificate courses on international contracts, infrastructure contracts, and offered advanced training program on government contract and law of tenders. He is a visiting faculty at Gati Shakti Vishwavidyalaya, a GSV, deemed to be university established by Ministry of Railways, Government of India. Further, as a visiting faculty, he has taught courses such as legal aspects of infrastructure business, contract management at Adani Institute of Infrastructure Management, Ahmedabad. He has also engaged session in the executive program in management for working professionals at Adani Institute of Infrastructure Management. He was the project convener of a project titled Effectiveness of Government Measures for the Reduction of Court Cases, which was awarded to GNLU by the Legal Department, Gujarat Government. He was also the project convener of Swarnim Gujarat project on speedy disposal of backlog of cases, an initiative of GNLU. Besides, he has also drafted some tender documents from GNLU side. Dr. Singh was the principal legal consultant for a consultancy assignment awarded by the Gujarat Maritime Board to GNLU for preparation of standard tender documents for various works of Gujarat Maritime Board. So we welcome you, sir, and I thank you for accepting our invitation, and I request you to begin the session. Thank you.
Thank you, Gauravji, for such a generous introduction. In the first place, I must appreciate this wonderful initiative, whereby participants across the country would get a great opportunity of knowing the teaching strategies for different law courses from galaxy of academic experts. Therefore, this law teachers India and Gujarat Maritime Board, who have planned to offer this kind of national level online faculty development program covering around 30 subjects. Now, for this initiative, the enthusiasm of Dr. Kalpesh Gupta deserves a huge round of applause. Now, coming directly to the topic which has been allocated to me, that is strategies for teaching contract law in Indian law schools. One thing I would like to make clear in the very beginning of my session, and that is, I am not going to teach you any aspect of contract law, because that is not the purpose of this FDP. Because in just 75 minutes or so, what all I can teach you, even if I take just one topic, perhaps the time will be over. And I'll not be able to do justice to the real spirit behind this FDP. Because as the title suggests, it's about strategies for teaching contract law in Indian law schools. You see, the object of this is to share with you my own experiences. At the same time, what do I expect from other faculty members teaching contract law? Therefore, you see, in my presentation, I am going to cover broadly these 5 themes. Now, in the first place, you see, whenever we are asked as to how to teach a law course, how to teach a particular law course. In the first place, I say there are some attributes of any law teacher. In fact, for that matter, the attributes which I am going to discuss with you, these are the attributes which are mandatory requirements for any university teacher. It's not just about a professor teaching contract law, right? It's about general attributes of a university teacher, that is an academic. Now, again, to the list of attributes which I am going to discuss with you, you can freely add to that, or you can slightly modify also. And therefore, the list is not exhaustive, but by and large, it will cover the whole range of attributes which are expected of any law academic. In the first place, needless to mention, it should be the subject knowledge. As a teacher, as an academic, we must have command over the subject knowledge. Then the second aspect is about legal language. Now, many a time I see there are teachers with very good knowledge of the subject. However, the legal language comes as an impediment. You see, when I say legal language, it is not just the English language or the language in which you teach, which can be any other language. But then taking example of English language, you see, legal language is different from a general English language. Now, I take examples from contract law. You see, many a times we see in books and in other scholarly writings also, and in discussion also, we use expressions. I mean, you see, you must have heard people using some expressions interchangeably. Taking examples from contract law, for example, rescission of contract, repudiation of contract, termination of contract. Tell me, do people not use these expressions interchangeably? Feel absolutely free. Do people use interchangeably or not these expressions? More often than not. Kalpesh, is it possible that participants can interact also in between?
Definitely, sir. Participant, you can
Because I do not follow a very strict and rigid structure of first session and then question answer, because let it be purely on interactive mode, because this is also actually one of the styles of teaching. I mean, I recommend all my faculty colleagues. So all of you are absolutely I mean, you are permitted to interact in between. You can just write your questions also. I can just see, right? I see. Yeah, I could see some responses. Yes, people say that yes, which means they do hear these expressions being used interchangeably. Actually, if you see, all these expressions have specific meaning. Repudiation is entirely different from rescission, and rescission is different from termination. So the point which I am trying to make is command over legal language is extremely important, because it is the legal language which will make you precise, which will make you specific. You will be to the point. So first attribute was subject knowledge. Second attribute is command over legal language. And then comes the third one, that is communication and delivery. You see, communication is different from language. And that's why I deliberately mentioned these two as two distinct attributes. Communication and delivery means reaching out to the audience. Now, you must have in your life come across situations where you see that a faculty member is otherwise very good at language, whatever language. But then you see that students may say, or even as a participants, you feel that you can't actually get the professor, although the language of the professor is very good, which means there is some issue with respect to the communication and the delivery part. We must, as an academic, when we go to the class, we must remember one thing, that we are not there to exhibit our command over words, which we must have. But the idea is to reach out to the students in the simplest possible fashion. You see, at times I come across propositions that we can't oversimplify. Oversimplification may dilute the concept, will dilute the subject. In my view, it is absolutely wrong argument. Presenting any concept in the simplest possible way is the most difficult task, rather. Is the most difficult task. Therefore, as if professor, let us try to be as simple as possible without diluting the concept, without lessening the legal contours of the words which we are using, right? Then you see, fourth attribute is about passion. Fourth attribute is about passion. Without passion, we can never do full justice as an academic. Now, when I say passion, means I have strong subject knowledge, I have very good command over legal language, I am a good communicator, right? I can, my delivery style is really good, but then still, with all these also, I may not be the ideal teacher if I am not passionate about my subject. Passionate about subject is very important. One should have passion for one's subject. In the first place, I believe as a law professor, I must have passion for legal education. And then whatever subjects I teach, I must have passion for the same. And the fifth attribute, which is actually extension of the fourth one, but then I want to discuss that as a separate attribute, and that is a feeling and conviction that you as a faculty member are doing the best job. When I take up this teaching assignment, I must have a strong feeling with conviction that the job which I am doing is the best job. You see, unless I have this feeling, this is, related to passion, but it is more than, it is different from passion also. Passion in means falling in love with the subject. Having, feeling and having conviction that I am doing the best job means I must respect legal education. I must respect the subject which I teach. Let me tell you, unless I have respect for legal education, I can never become a good law teacher. Respect all other disciplines, respect all other professional programs, but then have utmost respect for legal education. Do not undermine legal education. See, we may have problems with legal education, but that does not mean that legal education per se becomes bad. Legal education per se becomes, a professional program of lesser importance. So I believe that these five, attributes are extremely important. Dedication is associated with passion, so we can also write dedication and passion. So that point can be very well taken care of, right? Then you see, having seen the attributes, the second point is about skills. Now, there are some set skills, right? So, what do we mean by skills? Now, you see, along with the attributes, let me tell you a few more aspects before I come to this skill aspect. You see, what are law teaching attributes? What are law teaching attributes? Because general attributes, I mean, whatever I discuss, that's applicable to any discipline. But then what are law teaching attributes? In the first place, for example, I have got contract law to teach. Then in the first place, as a faculty member for the contract law subject, right, I should in the first place understand the subject, and I must make my students understand the real importance of the subject. You see, today contract law is the backbone of business world, and not just today, it has always been the backbone of the business world. And with the advancement, with the development, with more development, the importance of contract will increase further. So you see, about contract law, it is an inevitable subject for any field of practice and any type of employment. So when I go to the class for teaching contract law, I must in the first place instill the idea in the minds of my students that what you are going to study is a very, very important program, a very, very important course, because it is the foundation on which the entire business world rests. Without this foundation, business world will collapse. Foundation must be very, very strong. And that's why you see any kind of business dispute, it has some or the other correlation with contract law issues. Because if students understand in the first place that the course is extremely important, let me tell you, you have one half of the battle, which means students must attach importance to the program, to the course. And who has a duty of making the students realize the importance of the course? Faculty concerned. It is the teacher who has to make this instill this feeling among the students, right? Now you see, I normally in my conversation with my colleagues, I normally mention, I take this example with my students also, I take this example. You see, these days there is a fashion for advanced courses, advanced subjects. Well, not a bad idea, very nice. But then all advanced concepts in whatever discipline, whether it is science, whether it is law, whether it is social science, humanities, all advanced concepts are based on fundamental concepts. In this regard, normally I take the example of colors. You all know primary colors, secondary colors, tertiary colors. What are primary colors? Anyone? How many primary colors are there, by the way? Quick, fast. Let me just see the chat box. 3, very good. Priyank Shukla, very nice. Red, green, and I think Santi wanted to mention blue, it seems. Oh, a lot many of you have given the right response. But I think green is not a primary color, although we are not discussing that, but just, on lighter note, green is not the primary color, my dear, faculty colleagues. It's red, yellow, and blue. These are the primary colors. Now, the point which I'm trying to make is this. You see, there are primary colors. And then there are secondary colors. Now, which are the secondary colors? Orange, green, and violet or purple. These are the secondary colors. And how are secondary colors made? How are secondary colors made? Immediately fast. Mixing primary color. Yeah, this is one. Puja Lakshmi and then Soma Sarkar, mixing primary colors. Now, this is what I wanted to actually convey, right? And then further we have tertiary colors. So how do we form tertiary color? When primary color is mixed with the closest secondary color, then a tertiary color is produced, right? Now, you see, advanced concepts, they are based on fundamental concepts. Advanced law courses are based on fundamental law courses. You see, cyber crime, right? Now, cyber crime is based on principles of criminal law. Cyber crime may be an advanced issue, but it is based on the law of crime, which is the primary law course. Similarly, contract law is the primary law course. Constitutional law is the primary law course. You can have some advanced courses on constitutional law, right? But then advanced course of constitutional law is always based on the fundamentals of constitutional law. So contract law, constitutional law, tort law, criminal law, international law. See, these are all primary subjects, primary law courses. We must attach highest possible importance to primary subjects, primary law courses, because if we know these primary courses, then only we can develop any advanced law course on that, right? For example, if I want to teach some advanced course on criminal law, in the first place, I must know the principles of criminal law. I must know the primary colors, like the primary law course, right? Then I come to this second part, that is your skills. What skills? Now, attributes we understood, right? What all the law professor teaching contract law should possess. Although I told you that attributes are general in nature, they are to be possessed by law academic teaching any law course. Then coming to the skill point. Now, when I say skill, I mean the art and the management of classroom teaching. You see, it is more than attribute. Attribute, fine, whatever I have. But then I must be a skillful academic. Skillful academic, right? And I also see many people saying academician. Actually, academician is the wrong expression. The correct expression is academic. And that's why you must have noticed that many a time I use the expression academic. The distinction I can tell you now also, but I give you a task. You just try to find out what is the exact distinction and which is the correct expression. Grammar, right? From the grammar point of view, the correct usage is academic. Anyways, coming to the point, because I am discussing legal language also, you must know that very well. Now, skill means the art and management of classroom teaching. Now, what is this art and management of classroom teaching? You see, as a teacher, I must address the entire class, right? Now, at times what happens, owing to several reasons, sometimes a teacher end up addressing one section of the class, maybe the first 2-3 rows of the students, right? The teacher must address the entire class. The teacher must pay attention to each query coming from any corner of the class. This is what we say, art and management of the classroom teaching. As a faculty, when I go to the class, in addition to addressing the whole class, the entire class, in addition to paying attention to each query coming from any section of the class, I must also be mindful of another very important point. You know what is that? I must pay extra attention. I must pay a special attention to the weak students of my class or the slow learners of my class, because I believe I owe a duty to the entire class, number one. Secondly, I owe extra duty to my slow learners. So, as a faculty, I should encourage the entire class, number one, and then I must also encourage the slow learners. Right? You must be generous in complimenting to their responses. What other ways you evolve, you devise, it's up to you. But then that is your skill, right? Then only you can take the entire class together, because as a faculty, it's my duty, right? So how to strike a nice balance? It depends on situation, but then striking this kind of nice balance is the duty of a faculty member, right? So you see, after having seen the skills part, let me come to the methodology part. This is very important, right? What methodology one should adopt. Now, some of these I follow in my classroom, right? And you can also devise some more ways. In the first place, I believe that for any statutized law, any statutory law you are teaching, for example, if it is say contract law, IPC, transfer of property, right? You must make a non-negotiable condition in the class. And what is that condition? All students must compulsorily carry the Bear Act. Because you see, it shouldn't happen that a student has studied a course, but a student is yet to be acquainted with the Bear Act. This belongingness, this acquaintance with the Bear Act is extremely important. You see, ultimately, it is the Bear Act which provides the statutory provisions, right? That is the law actually. And then read the commentary, judgments, fine. But then you should know the legislation, right? You should know the legislature made law, that is the statute. And how can you do that? You can't expect a student to just 2 days or 1 week before the examination developing some sort of acquaintance with the Bear Act. That's not possible, because the language of the Bear Act is not that easy to understand. But then if you follow this practice throughout the semester, I am quite sure that your students will certainly develop that much needed acquaintance with the Bear Act. And what do you do, which I normally do? For example, if I teach transfer of property, right? Or let's say somebody is teaching contract law, you are going to discuss, let us say, section 27. You ask a student, please read section 27. Now, when you ask a student, now he is compelled to read that section. So while reading the section, he gets to know what section 27 is. Similarly, you keep on asking different students, different sections to read whenever you are discussing those sections. And then correlation also. Say you are teaching section 75 of the Contract Act. Then you can immediately ask, read section 19, read section 19A. Some sort of correlation you have developed when you are discussing, let's say, section 56, right? And then immediately you should refer this to, you should correlate this to section 32 of the Contract Act, right? Your frustration of contract, force majeure part, you can discuss. You ask students to read the Bear Acts, right? Now, this way, you have achieved another aspect. And what is that? Now you are engaging the students actively. And then students in your class should get a feeling that they can be asked at any point in time. Now, if they get this kind of feel, then they will be more vigilant in your class. They will be more, now it may start with being more vigilant, and thereafter they will be engaged. The idea is, see, the process may vary. So our role is to engage the students actively. What does it mean? It means active participation of the students. Let me tell you, my faculty colleagues, the minds of our students are fertile. The minds are fertile. But still, only fertility of the soil is not sufficient. Soil is fertile. But what more do you want? To have a very nice produce, to have a very nice harvest. What do you need? Let me see some responses. Responses? Working hard, seed, good quality seeds, proper care, right? You put in water also, manure also, nourishment also. Now, who will provide all these? Who will provide all these? The teacher has to provide. Because students come to your class with fertile mind, right? Now, it's our duty to provide the nourishment, manure, water, which means then only there can be a very nice desired produce, right? Then regarding the methodology part, you see, I'm not going to use PPT. Absolutely use it. Even if you're using PPT, I don't mind that. But remember one thing, PPT is for students. It's not for the faculty members. Remember one thing. Use any IT tool. I do not mind. But then bear in mind that the IT tools which you are resorting to, they are for your students. They are not for you. Which means you should not depend on, you should not become handicapped, right? So all those things apart, then I normally see, and I say my students in the class also, what do I say to my students? I say, do not write much. In fact, you see, some of the students, their countries busy in writing only. See, and then I do not rule out a possibility that there are some very good students who can write, who can listen to you also, who can manage. But then this cannot be a general rule, right? I believe while I teach, my students should pay attention to my delivery aspect, attention to the concept which I am trying to make them understand, rather than merely writing. Again, and I say, no, write as less as possible. Only the key points. Key points are fine. Certain important cases you can just mention, right? But then, see, for example, some cases also, I mean, suppose I'm showing PowerPoint. On my PowerPoint, the cases are there. So you can just refer to the cases later also. And if you want to write, you can just write. But do not simply write the whole narration. Then your attention is more in writing rather than listening to me. Listening to means not the bare listening to me, rather than trying to understand what I am conveying in the class. Then such students who are continuously in writing, you must have noticed that they do not ask too many questions. The reason is they are busy in writing. In my view, it is not a very good way of learning, right? So if possible, you ask your students to write as less as possible, write only the key points, and pay more attention to your delivery aspect, and ask questions as and when questions come to their mind, right? Then regarding the methodology part, I, especially in case of contract law, I say that In fact, I believe that for any law course, and which is equally applicable to contract law, full length case studies, at least in one semester, for one law course, minimum I say 5 full length cases must be studied. If you just try once, but full length means full length does not mean one paragraph, 1 page or 2 page. Full length means even if it is a 10-page judgment, 15-page judgment, you ask all the students to read the full 15-page, 20-page judgment, and then you discuss. You ask one student to tell the facts, one student to tell the arguments put forward by the plaintiff, arguments put forward by the defendant, judgment, analyze the judgment, ask what what has been the impact of that judgment in the future cases, right? So you see, full length case studies, they should become part of our teaching methodology. But then I'm not saying that only case studies, but then they are inevitable part. For example, if I say that I taught one contract law course for one semester without having discussed one full length case, then I believe that there was some shortcoming. Even though I did my job very well, even though I did my job very well, what do I mean by this? I mean, if I had discussed 5 or 4 full length cases, then the job which I did very well would become outstanding actually. My potential is not just very good. I perform less than my ability because students learn less than what they could have otherwise learned had they been involved in full length case studies, had they been required to read full length minimum 5 cases in one semester. And contract law, particularly the principles of contract law, they are primarily principles evolved through various judgments, right? So just focus on this part. Then another important aspect of teaching contract law is discussing with the students clauses in a business contract. You see, in many of the law colleges, you may find that students study contract law 1, contract law 2, but then without having seen one single contract, real world contract, I mean, 4-page contract, 5-page contract, 2-page contract, 10-page contract, 50 or 100, whatever. In my view, this is not so desirable. You should ask your students, they need not go through a very lengthy business contract, but then they can certainly go through 5-page contract. Maybe 3 contracts you can ask them just to read on their own and then come to the class. Just any 3 contracts. Right? Now, students should know, what I mean, how a real world contract looks like. What are the clauses in a business contract? Now, how do you bring in? I'm not asking you to offer another course on contract drafting or drafting business contract, which may not be possible because time may not permit you. But then still, it's doable. How is it doable? For example, you are discussing termination. Then you can just show in the real business world, you see this kind, a termination clause looks like this. You can just show that time also, right? You can just show that time also, so that they should understand not only the concept behind termination, how is a termination clause drafted, without teaching them the drafting aspect. Just they should see at least how a termination clause looks like. Similar remedies clause, different kinds of remedies. You can just show the clause, right? Now, I mean, I would say if you follow these methodologies, perhaps you can end up doing a better contract law teaching. Then another important aspect of contract law teaching is what are the topics which are to be covered. Now you see, as per the PCI requirements, there are 2 papers on contract law, right? That is Law of Contracts 1 and Law of Contracts 2. In the beginning, Gauravji did mention what all things are included in Contract Law 1, obviously general principles of contract law and specific reliefs. Then in Contract Law 2, you find some specific contracts, plus sale of goods, partnership. Now, this is one more thing which you all would agree with me, and that is a subject is not fully covered, a course is not fully covered. Now, while I understand that it's not possible all the time to cover the course in one semester, but see, is it not possible for us to provide an overview of the entire course and then doing some sort of selection? What all topics to be given greater weightage and what all topics can be just covered summary fashion, right? My point is a course should be, the entire syllabus of the course should be covered, but then how to cover and what all topics to be given greater weightage, that is to be left to the faculty concerned, and that is to be decided by the faculty concerned, because I know what all things are more important. Obviously, whenever you see, in case of contract law, fundamental principles of contract law, they are the most important thing. Other aspects can be taught in less time, but then main focus should be to the principles of contract law. But as regards the other points, we must provide an overview of the those aspects. Otherwise, you see, students will never get the second chance to learn the subject in the classroom environment. It's very simple. For preparation of different competitive examinations, etc., they may, but then classroom teaching is always a classroom teaching. There is no substitute to classroom teaching, mind well. And and secondly, a very important point, every time any law professor would say, that is, a statute should be read as a whole, right? We always say statute should be read as a whole, and which is a correct proposition. Statute should be read as a whole. But then, do we study the statute as a whole? Do we ask our students to study the statute as a whole? No. Right? So, a statute should be read actually as a whole. Right? We should see, for example, general principle 1 to 75. There should not be any compromise on 1 to 75. And then specific relief act. Even if I do not have, let's say, 10 hours to complete specific relief act, in 5 hours I can complete. I can provide an overview, right? Giving greater importance to some aspects and covering other aspects at a relatively fast pace. But then I believe we should not omit. We should not omit, because then we are not reading the statute as a whole. And that too, when the statute is like Contract Act, such an important statute, extremely important statute, right? You see, I share one experience. I asked the students while teaching a topic. The question was regarding rectification. And I asked, what do you mean by rectification? Have you ever come across the word rectification? Rectification of this, that? It was obviously in relation to a contract only. Then students gave different responses, meaning of rectification, correction, this, that, and all those. But then you'll be surprised, not even one referred to the specific relief act. Not even one single student referred to the specific relief act. Do you say it's a good thing? Yeah, tell me, please. Very good. Ashutosh Panch Bhai. Yes, you are right, Ashutosh, and Nikita also. Very nice. You see, Rakhi Poonawala as well, right? Now, this happened. I mean, this kind of situation could happen for because they did not study specifically the fact, right? Because section 26, there's only one section on rectification of instrument. Instrument including contracts. Contract is a type of instrument, right? So statute should always be read as a whole. So when I say topics to be covered, because in the beginning only I know that as a faculty I'm going to get, for example, 60 sessions. Now I should chalk out the sessions in such a manner that I end up covering the entire statute, right? Then for covering, I can decide what all topics to be given greater importance, what all topics can be covered at a relatively fast pace. And I can also give self-study assignment to the students and then ask the students somehow to get engaged in those areas. The point is, students must study all aspects of contract law. That is my point. Other laws as well, but contract law I am discussing. And then correlation of the course with other courses. Just a while ago, I saw one of the responses by the participant that was about IT and contract. Yes, you are right. You are absolutely right. You see, whenever I teach contract law, some other laws will obviously come into play. For example, tort law, IPC, obviously, whenever you are discussing, let's say, unlawful consideration, unlawful object, the law which immediately comes to our mind is, and in the cases and illustrations also which come to our mind is instances from IPC, isn't it? From the IPC. So, correlation. Whenever we are discussing unlawful object, criminal conspiracy, the best example, immediately take criminal conspiracy situation, right? That's an agreement, but not a contract. So, this way, correlation with other courses. For some aspects of contract law, Evidence Act, we need to refer to Evidence Act. CPC, right? So, the point is, whenever we say what are topics to be covered, in that we must always try to develop the correlation of our contract law with other law courses wherever possible. Then I come to this aspect, the second last point, theoretical and practical importance, right? So first we saw attributes. Within attributes, if you say I can summarize later, but then first was about attributes, second skills, third methodology, fourth topics to be covered, and now comes theoretical and practical importance of here obviously contract law, for that matter other laws as well. You see, one point I would like to share with all of you here, and which I have been discussing with my colleagues also, and like me, you all must have observed this also. You see, some of our judges and lawyers, when they address law students on whatever occasion, you see, at times they end up sending a message that the real learning of the law starts in the courtroom. I believe some law professors also believe, I believe, as a judge, as a lawyer, and as a law professor, we should never make this kind of statement. Because in that sense, we are undermining the legal education. I am not saying that state of legal education is absolutely perfect everywhere. No, it's not the case. But then, due to some shortcomings, due to some drawbacks, due to some sort of lack, we can't generalize. We can't say that the real learning starts in the courtroom, right? We should never, as a law professor, we should never say that real learning of the law happens in the courtroom. You see, as I said, there are colleges where classes might not be conducted properly, regularly, but then that cannot become the general rule. If one has not received very good education in law, then one cannot undermine the legal education, which is important in the classroom. Because you see, what classroom provides can never be substituted. Because theoretical basis and the practical importance both are equally important. Our students should be informed of both the aspects very well, right? Both the aspects very well. How to strike the balance between the theoretical aspects and the practical application of law? It is for the law teacher to determine. It is for the law teacher to take care of, right? So while teaching any law, I can bring the practical application, and I must bring the practical application of that law. Then only, number one, I can be more convincing. Then only I can do real justice to the course. And then only I can engage my students. Because students do expect practical utility of the concept. And let me tell you, there's no concept without practical utility. It's for us to make them realize the practical utility, right? So, this theoretical basis, the fundamental concepts of any law, here contract law, are the most important things, because the foundational courses, why do our programs have some compulsory courses? Because without these courses you cannot practice law, you cannot understand law, and then understanding of the law can be done only in a proper classroom, right? You see, one can obviously pick up one book, 2 3 books on a subject, read and understand, but then that can happen only in respect of 1 or 2 areas, but that cannot happen in general, right? And the role of a teacher in developing the concepts is non-negotiable. It cannot be simply substituted or replaced by any other office. But then the law teacher must do that. If there is failure on our part in completely making our students understand the theoretical and the practical importance of the course, then situation changes. Now, the last part is about new dimensions of the contract law. I could see some responses, in the chat also. It was about, some, concepts like e-contract I just saw, right? I'm just coming to that point only. Now, you see, new dimensions of contract law. See, every law keeps on developing. Why is it so? It is so because law is an organic subject. Law is an organic subject, and contract law, supremely organic subject. Supremely organic subject. The way contract law is expanding, you see, the way criminal law is expanding, right? The way information technology law is expanding. So, law is an organic subject. Therefore, it has to evolve. Now, who will take care of the evolving dimensions of any subject here? Let's say contract law. It's whose duty it is to discuss the newer dimensions of contract law, the evolving dimensions of contract law. I say it is the faculty only, right? Discussing things jurisprudentially is the role of a faculty member more than any judge, more than any lawyer. I say with full conviction, right? More than any judge, more than any lawyer, it is the role of a law teacher to discuss the evolving and ever growing dimensions of any branch of law. You see, coming to contract law, I used to teach contract law 1 and contract law 2. I taught, these two courses for a few years. And then somewhere around 2009, 10, 11, I used to discuss with my colleagues also that there is a need for contract law 3. That is how my, journey started with the in the direction of developing a new course altogether. So what I thought that contract law 1 and 2, they're non-negotiable, very, very important, most basic, most fundamental. But then these two courses are not sufficient to deal with all the aspects of contract law. Principles of contract law, very nice. Specific reliefs, very good. Specific contracts like indemnity, guarantee, bailment, agency, partnership, sale of goods, absolutely fine. But then now the time has come when it is obligatory and it is actually indispensable on the part of the university to look at the newer facets of contractual jurisprudence, which confront the modern day contracts, which were hitherto uncharted, hitherto unexplored, right, at the UG or the PG levels of our university, any university in general. Now, considering these aspects, I actually end up developing a new course altogether, which is, I just told advanced contracts evolving jurisprudence in contract law. About this point, I already told you BCI mandates these two courses, contract law 1 and contract law 2, right? So we need to explore and address the evolving jurisprudence of this course. And then these should be the objects of our contract law program. You see, the objects are, quite clear. Now, in the first place, any contract law course, whether it is contract law 1 or contract law 2, or both the courses put together, our object should be to apprise the students of the conceptual parameters and operational parameters of the principles of contract law, right? And then specific contracts, obviously, we need to tell them about, right? Obviously, drawing support from the principles of contract law. Then application of contract law. Now, for the purpose of application of contract law, we need not have another course. In the same contract law 1 or contract law 2, we can tell the students about how these concepts or how contract law is applied in the real world. And then the relevance of contract law in the globalized commercial life, which is very, very important, right? Then how to develop the critical appreciation of the legal framework of newer types of contracts or advanced contracts. I'll just discuss this. And a very important aspect is, we must always try to, tell the students about various clauses of a contract, what they are meant for. Now, this is the course which I just discussed with you, because based on my own experience, I developed this course. I gave the title as Advanced Contracts Evolving Jurisprudence in Contract Law. Now, I told you how I developed this course, because I thought that 1 and 2, although very important, but they do not cover the whole range of aspects, whole range of issues which are actually dealt with in the real world. There are several new types of contracts which have come into existence, and at the same time there are some certain aspects of contract law not new, but unfortunately they are not covered during our undergraduate program. They are not covered. I'll give you examples also, right? Feel free should you differ from my positions. Now you see, these are the different modules of this course, right? Now, newer types of contracts, for example, this electronic contract. This is a new type of contract, isn't it? This is a new type of contract. But we normally do not have any specific module in our law course, right? In a contract law course, normally we don't have any specific model. Some passing reference one can make here and there, that's fine. But then, should our students not know what these electronic contracts are? Obviously, starting from those cases where telephone was used for making contract, telex was used for making contract, fax, emails, website contracting. We need to discuss all these aspects, the jurisdictional issues, right? Then infrastructure contract. Now you see, with the involvement of private participants in the development of infrastructure in the last 30 years, at least in our country, you see a lot of infrastructure developments happening. At the root of any infrastructure development lies infrastructure contract, right? When infrastructure is developed by involving private parties, then the contractual arrangement which is made between the state on the one hand, state under Article 12, and the private players on the other hand, that kind of contractual framework is called as PPP, public-private partnership. Public-private partnership is a contractual framework. PPP is a contract, right? PPP is a contract. So, what are the different facets of infrastructure contract? Our students should know, right? So, these are some newer modules. I mean, discussing newer types of contract. For example, in the same category, I put surrogacy contract. Before 1978, nobody knew what is this surrogacy. You know, the first child was born in the UK, and the second child was born in our own country, India, in the year 1978. And since then, surrogacy has developed only. And now we have got Surrogacy Regulation Act also, right? So surrogacy is also essentially a contract, right? Now, you see, again, smart contract is a new type of contract. Now, while these are some modules dealing with the newer types of contracts, I draw your attention to those aspects of contract which are not new. But to my knowledge, if not 100%, I say 99% of the universities and colleges, they do not teach these aspects of contract, and which are of extreme importance. And I must here mention interpretation of contract. Now, in books also, whether you say any commentary, I do not want to mention any particular book, any commentary take, any good book you take, how much space has been devoted to interpretation of contract aspect. And normally when you study, when you studied, when you teach, how many times do we discuss interpretation of contract? Because interpretation of contract does not mean passing reference. Interpretation of contract does not mean only saying intention of the parties. That is not sufficient. right? How many times do you see somebody discussing interpretation of contract? Please. Ashutosh, what's your response? So somebody said never discussed. Santi says an aspect that is not covered, an aspect that is not covered. See, who is this Ashutosh? Yes, sir, interpretation of keyword. No, that is different. Yeah, Ashutosh, interpretation of keywords and phrases, they are different from interpretation of contract. Right, Ashutosh? Neha says never, which, right, Neha? Normally it is not. And now tell me, I don't want to teach you interpretation, by the way. The subject which I like very, right, very much actually. Now you see, take any contractual dispute. You know what happens, dear colleagues? Whenever any dispute arises and the matter goes to the court, what is the role of the court in contractual dispute? What is the role of the court? Well, you can speak also some, right?
Yes, Prabhat, over to you. Prabhat, over to you. Participant, you can raise your hand. I will unmute you. Prabhat, over to you. I have unmuted you.
Okay. Interpretation of facts and circumstances to judge. You see, role of the court to brief, Prabhat, I can see your
Yes,
hand.
yes, sir. Am I audible?
Yes, please.
Yes, sir. Regarding e-contract, sir, I have one question that while downloading the app, while visiting the website, we click on I agree. Mostly we go to the provisions of the contract. So is this a valid consent as per modern contract law?
Good question, Prabhat. You see, this is nothing but a standard form contract. Now, the only difference is electronic setting is used, right?
Yes, sir. Yes,
See,
sir.
for example, if Prabhat, when you open email account, you see this kind of terms of use.
Yes, yes, sir.
Now, I mean, the terms of use are brought to your attention conspicuously.
Yes, sir.
Just like let us say this is an insurance this is, let's say, an insurance contract, right? All the terms are brought to my knowledge. I do
Yes.
not read, and in the end I simply put my signature at 2 3 4 places.
Yes, sir.
Is
Sir.
it a contract? No, Prabhat, is it a contract or not?
Yes, sir. It is a contract.
Which means the moment I signed, I agreed to all the conditions. With see, in reading is not important. Agreeing to the terms is important, and by putting my signature, I give my assent to the terms. The same thing which can happen in the physical world, the same can happen in the electronic world also. So, if the only requirement of the law is that the terms must be brought to the attention of the user in
Yes, sir.
a reasonable manner, that is, in a conspicuous manner. If this is done, the reader, by clicking I agree, he agrees to the terms. But then, if I do not bring the terms to your knowledge and I try to bind you by the terms which you have never seen or which were never brought to your attention in a reasonable manner, then you are not bound. So, you see, the same principles are applicable even to electronic settings.
Yes, sir. I have another question related to that, sir.
Okay,
Sir.
before that, Prabhat, before you ask a question, actually, my question was about interpretation of contract. Let me conclude that point. You
Oh,
see, whenever any contract law dispute arises and matter goes to the court or goes to the arbitration. Now, whether arbitration or court, they are to decide the dispute. and they decide the dispute by reading the contract, which in technical terms we say by interpreting the contract. So in any contractual dispute, by and large, the court interprets the contract. Now, for interpreting the contract, there are some principles. There are some rules of interpretation. Now, you see, when we say interpretation of statute, do you have good books or not? Interpretation of statute? You have G.P. Singh, you have N.S. Bindra, you have Binion, right? Isn't it? You have good number of books. You have a book by Markandeya Katju, Mimamsa Rule of Interpretation, right? But then if I ask you, do you know any book on interpretation of contract? There is an acute dearth of scholarship on interpretation of contract in India. But you see, it's such an important. I know, by the way, a lot of foreign authors' book. I can tell you also. You see, that on contract fine, but that is not on interpretation of contract, Sangeeta. Now you see, interpretation, in my view, is the most important module of this course. Even when you are teaching contract law 1, you must bring in some element of interpretation of contract. When I teach this advanced contract course, I devote some 8 to 10 sessions only on interpretation of contract. 8 to 10 sessions only on interpretation of contract. It is such an important. The point which I am trying to make is, it is not a new concept, mind well, because interpretation of contract is as old as contractual dispute, as old as the concept, because contracts used to be decided 100 years ago also, 200 years ago also. The judges used to decide based on interpretation of contract. There are some principles of interpretation, rules of interpretation of contract, right? So this is an important module, although not new. Similarly, I take one more, government contract and law of tenders. You see, law of tenders such an important. You see, if you see last 10 years judgment, Supreme Court has given so many judgments on law of tenders. I believe that law of tender is an ocean, and if you develop expertise in the field of law of tenders, you have ample opportunities. You can do a lot of consulting assignments, But then, unfortunately, law of tenders, this does it figure anywhere in any of our law program? I'm asking you, any of the law course? If it is so, I'll be very happy to know that. Do you see law of tender part of any of the law course? Sometimes in administrative law, while teaching some of the aspects of administrative law, you can just mention tender was floated, this and that. But do you find law of tenders? You don't find. Some passing reference you can see in constitutional law book, and even in constitutional law book you won't find commentary on law of tenders. Similarly, in your administrative law also, you don't find law of tender. Law of tender is essentially a contract law issue. So should it not be taught in the law school? Because there are so many cases. Oh, somebody wanted to know. No, but then Kanan, when you say only while teaching invitation to offer, you are right. But then that is insufficient. There are so many things which we must tell the students about law of tenders. In this regard, you can just refer to General Financial Rules 2017. It is by Ministry of Finance, Government of India. Now, somebody wanted to know the book name on interpretation of contract. Yes, Dr. SMI, right? You see, one book is by Kim Levison, Sir Kim Levison, Lewi. It's Sweet and Maxwell publication. Sir Kim Levison is one book. Second book, if you want to write, you can just write Gerard McNeill, Gerard McMeel, Gerard McNeill. It is by Oxford University Press, OUP. Gerard McNeill is a professor of law. Sir Kim Levison, he was a judge. Sir Kim Levison. 2 books you can just see. If you want to know, I can tell you other books. For example, one is by Richard Calnan, Richard Calnan. It is also by OUP. Fourth book is by Stephen Burton, Steven, Stephen Burton. This book has been written from, this is also by OUP. It has been written from US perspective. One more book you can write. The title of Gerard McMillan's Construction of Contract, and the title of Kim Levison's book is Interpretation of Contract. The title of Stephen Burton's book is Elements of Contractual Interpretation. Elements of Contractual Interpretation, yes. You can write one more book by J.W. Carter, J.W.C.A.R.T.E.R., J.W. Carter. That is also a good book. So, in this module, in this course, I cover these modules. Similarly, you see, there are modules on joint venture and shareholders agreement, entertainment and sports contract, right? Surrogacy contract, medical contract is also very important. Smart contract, you should teach. General clause in a contract. So I tell my students, what are the general clause in a business contract? The purpose of these clauses in a business contract. So the students should understand, why is this clause in a contract? What purpose does this clause serve in a contract? What care one should take while drafting the clause, without telling them how to draft, because drafting is altogether a different course. Then you see hospital or medical contract. You see, when you say case of medical negligence, it's basically a tort case. Negligence is basically a tort. Negligence is a crime also. But then, is there a contractual relationship between a doctor and a patient? I'm asking this question to you. Anybody?
Yes, sir.
Yes, Ashutosh, what's your answer?
Yes, sir. There is. It is basically governed by the contract. It is a contract.
It is a contract. Very good.
Three dimension. In fact, from one angle, it is consumer contract as well. From one basic premise is still of contract, and considering that tortious element, so obviously that fiction of a common law, that is man of ordinary prudence, elevated to the extraordinary prudence.
Okay, fine. So when you say it's a contractual relationship, then can a patient sue the doctor for breach of contract? Second question, Ashutosh.
Yes, sir.
Hmm?
Yes, sir. Definitely.
Do you come across these cases?
Yes, sir. Actually, in consumer contracts, there are several cases.
For breach of contract or deficiency of service?
Yes, sir. It is actually in relation to the deficiency in service, but the jurisdiction of contract law is underutilized. It is less invoked. The preferred choice of the litigant is to knock the doors through medical jurisprudence.
No, that's fine. See, normally you see under Consumer Protection Act also, or other cases, constitutional cases, when you study constitutional book also you find, but those are mainly in relation to negligence on the part of the doctor. Now, in India, you can find very few cases where the patient sues the doctor for breach of contract. You see, it is essentially a contract. It's not a contract of service. It is a contract for service. And if a doctor expressly promises to produce a particular result, and if the doctor fails to produce that result, then the doctor is 100% liable in contract. Although in India, we do not have so many cases like this, because normally patients do not sue hospitals and doctors for breach of contract. Whenever they sue, mostly they sue for maybe for commission of some tort. For example, some scissors, etc. They are left in the abdomen while operating, and some other kind of negligence. One advantage of holding the doctor in contract is that even if the doctor took all possible due care, all possible care, there was no negligence on the part of the doctor, still the doctor or the hospital could be held liable in contract if the doctor or the hospital gave an express promise, gave an express warranty, and they failed to produce the same, then they are liable. Now, this should be studied, right? This is a very important aspect, right? So these are some of the modules which I which are there in my course on advanced contracts evolving jurisprudence in contract law. So if you are interested, you can just have a course like this in your college or your university also. Or if not, if it's not possible for you to offer a course, then you can offer this as a seminar course, or in your course on contract law 1 and 2, whatever you are teaching, you can bring in some of these elements, some of these aspects, so that it adds some value to your course, and it will make the students aware of these newer and the emerging dimensions of contract law. Now you can ask any question, whatever questions you have regarding the whole, right?
Sure, sure. Thank you,
Please.
sir. Swapnil, over to you. I have unmuted you. Swapnil.
Good evening, sir.
Good evening.
First, I would like to thanks to you, say, because sir, we are very glad to listen to you.
Thank you.
And sir, my a little question is that the law of contract is a purely civil in a nature. But if the party wants criminal action in case of the breach of the contract, so is it a criminal remedy?
See, an action can amount to a civil wrong or criminal wrong. An action can amount to a civil wrong or a criminal wrong, right? Then
Yes.
you can certainly go to the criminal court. But it is wrong to say that, see, if for breach of contract, you can't go to criminal court, right?
Yes.
Because it is a civil wrong. So you have to go to the civil court or the consumer, I mean, broadly speaking, civil courts. But if an act amounts to a criminal wrong also, if an act amounts to a crime also, then certainly the liability is in crime. Then you can go to the criminal court.
Yes.
Yes, Ashutosh, I can see your hand, Ashutosh ji.
Okay, Dr. Kanan, over to you. Ashutosh, I think. Dr. Kanan, over to you.
Okay, good evening, sir. Thank you for such an enriching lecture. Sir, the problem while teaching contract is like, say, general principles of contract, wherein communication rules and certain aspects where you can't ignore. But today's generation, they can't relate to that. Postal communication rules and all those. So that is number one. So how to overcome that? And as you mentioned, sir, that we can show few contracts, so when we search on the website, we seldom find those sample contracts.
I'm coming to your question. No, you can find good number of contracts, Kanan. That is not the case. You can find contracts. And secondly, I mean, your first question regarding communication, students cannot. No, let me tell you, good that you asked me this question. I believe that in India, 90% of the people do not know what is the general rule of communication of acceptance when complete. And I say with full conviction, 90% of the people do not know, legal professionals do not know what is the general rule of communication of acceptance when complete. Who will answer my question? Oh, quick. I'm taking this opportunity to just clarify some of the, maybe doubt or confusion. Oh, my question is, when is the communication of acceptance complete?
Sir, when
You
it
see,
comes to the knowledge of the person.
See, many people say they take help of section 4, right?
Right.
Section 4, my dear colleagues, section 4 does not tell us the general rule regarding acceptance. It is actually the exception. See, section, I mean, because you asked the question regarding communication, I mean, they can't relate to the postal rule. See, postal rule is actually the exception. It is not the general rule. General rule has always been the receipt rule.
Yes.
General rule has always been the receipt rule. And if you read that case, your English Indian case also Bhagwan Das Govardhan, and your English
Yes.
that's Endorse versus Miles Forest Corporation, the
Yes.
full length case, you'll understand the real reasoning given by Lord Denning in that case. You see, it is the receipt rule which is the general rule. To the receipt rule, an exception was engrafted in the form of postal rule. That is, when the letter is posted in the course of transmission, and that time the acceptor will post. So that time the proposer is bound. And when the letter reaches the proposer, the offerer, now the offeree is also bound. Now this is given in section 4, and this is an exception actually. This is an exception. The general rule is always the receipt rule. So Lord Denning has given some very nice illustrations in that case, Endorse versus Miles Forest Corporation judgment. Just read that, you'll get some good instances, and you'll get much better clarity on that.
Fine. Thank you.
And students can certainly correlate.
Yes.
When I teach, Kanan, you say your question was how to. When I teach this
Hmm.
to whatever participants of whatever program, then I say in the first place there was a stage when people used to physically meet. I mean, let's say some 200, 300, 400 years ago, people used to physically meet and get into contract. So in those cases, obviously, it was the receipt rule.
Hmm.
Then came the second stage of development, when some postal communication was some form of postal communication was it came into vogue. Then to address that, because they are not instantaneous, because if you are posting it on, let's say, 5th of a month, it will reach on the 10th of the month. It will reach the offering on 10th of the month.
Yes, sir.
Then in order to address the administrative convenience, the commercial expediency, a rule was to be engrafted. And then this postal rule came into being. That is, on the 5th of the month only, when the acceptance is dispatched in the letterbox, that time only the contract is made, and the offerer is bound.
Hmm.
Right? And then we come to the third stage of development, information technology.
Yes.
Right? That is email era or telephone era. The Endorse Miles Forest Corporation case regarding the telex, and our
Yes.
Bhagwan Das cases on telephone.
Yes, sir.
Now the same reasoning is applicable to email transactions, right? Transactions via other forms of instantaneous mode of communication, fax, etc. Now in this case, since there is no time gap or no substantial time gap between the dispatch and the receipt, therefore it is not the postal rule which will be applicable, it is the receipt rule which will be applicable.
Hmm.
So when I discuss this, I discuss in 3 stages.
Right.
Now students can very easily understand what was the situation earlier. Then to that receipt rule, postal rule or mailbox rule came as an exception. And then when it comes to the instantaneous mode of communication, then the general rule is followed rather than section 4 is followed. Section 4 is actually the exception to the general rule.
Okay. Thank you. Thank you very much, sir.
Any other question?
Thank you very much, sir. I think we should stop because I can hear so many comment suggestions. Inputs are there. I can go for more 1 hour. I can see, because I know your passion towards contract law, because I know like 2-3 professors in India, like we are talking about contract, so you are one of them, sir. So thank you very much, sir, for joining. I will share sir's email ID, and you can already share sir's book, that cover page in the
Law
group.
relating to electronic contracts.
Yes, sir. I have posted in the group, so you can go through it.
And if participants, Kalpeshi, if they want to know on certain aspects of contract law, because my object today was not to discuss any aspect of contract law, how to teach contract law, right? So if they want to know more on any other aspects of contract law, maybe one or two, I'll be more than happy to discuss later.
Definitely, sir. I will share a email ID with them. And then I remember you conducted the
And
2
if,
days.
whenever it's possible, say physical, I like physical classes much more than online. Actually, my dear colleagues, I do not like online sessions much actually, I believe in this physical classes more, but then it has its own advantages. People from any corner of the country, they can participate. That advantage is certainly there.
Sure, sure, sure. And so I certainly remember you conducted the 2 days, the training program, government contracts. I was part of that. I think it was in 5 years back. It was very enriching because in contract based, again, this kind of dynamics we should learn by day. So thank you very much, sir. I request Gaurav to give a vote of thank you, sir. Over to you, Gaurav.
Thank you so much, sir, for giving us such wonderful and useful practical insights for the faculty members to update themselves and adopt new teaching skills by understanding the nuances and intricacies of teaching contract law, subject in classrooms, and practical tips for better handling of students. Sir, you beautifully discussed and gave realistic guidance and advices to the faculty members, which can be summarized in following points like knowledge or command over the subject, importance of legal language, communication or delivery of the knowledge to students, making the students realize the practical importance of the subject, focusing more on primary subjects or courses first, and then proceeding towards the advanced courses, art and management of class teaching, addressing all students of class and paying more attention to weak students and slow learners as the extra duty of the faculty. Regarding teaching methodology, sir, you emphasized on importance of carrying bare acts in class by the students, as well as the practical teaching strategies and handling of students in classrooms. Sir, you also highlighted the practical benefits of teaching full-length case studies and exposure to clauses of real-world contracts as an inevitable part of the teaching methodology of the contract law subjects. You also emphasized on having the overview of the complete contract law subject, linkage of contract concepts with related provisions of other subjects, and giving equal importance on theoretical knowledge as well as its practical aspects and application. You also showed us the new dimensions and facets of contract law and the new course developed by you as Advanced Contracts Evolving Jurisprudence in Contract Law. Lastly, you stressed and focused on the jurisprudential aspects of contract law, interpretation of contracts, specific branches of contracts, examples, and related issues. Once again, thank you so much, sir, for this informative session. I would also like to thank Dr. Kalpesh Kumar Gupta, sir, and his entire team for this enthusiastic initiative to provide us a common platform where we all can benefit by learning new innovative ideas as well as practical teaching methods and strategies of particular subjects by renowned expert resource persons just by sitting at our homes. Lastly, I would like to thank all the participants for their patient listening and active interaction in the session. Thank you.
Thank you. Thank you very much, sir. Look forward to see you in future events.
Thank you, everybody.
Thank you, sir.